Hello everyone and welcome back to Law Statistics. Today's presentation is based on 25 landmark cases in Supreme Court history. So, the first case is Lochner versus New York, 1905. In this case, it was held that the Constitution bars a state from interfering with an employee's right to contract with an employer. It was held that individuals have a right to contract with employers and state cannot interfere with that right. Furthermore, in the case of Marbury versus Madison 1803, it was held that a law repugnant to the Constitution is void. The court held that the power to review all acts of Congress where constitutionality was at issue and judge whether they abide by the Constitution or not. Furthermore, in the case of Munn versus Illinois in 1877, it was held that businesses that serve the public interest are subject to regulation by state government. Here, the court held that if the rates were not satisfactory, according to the owners of the companies, the complaint should be taken to the legislature and not to the courts. Furthermore, in the case of Dred Scott versus Sandford 1857, it was held that the Constitution does not consider slaves to be US citizens. Rather, they are constitutionally protected property of their master. Also, in the case of Charles River Bridge 1837, it was held that the responsibility of the government is to sacredly guard the rights of property for the prosperity of the community. Also, the court here said that the responsibility of all government is to promote the happiness and prosperity of the community. Also, in the case of Gibbons versus Ogen in 1824, it was held that when a federal and state law are in conflict, the federal law is supreme. Here, the court gave a statement that the supremacy clause tilts the balance of the power in favor of federal legislation, and hence the federal law is supreme. Also, in the case of MC Culloch versus Maryland in 1819, it was held that let to the end be legitimate, and all means which are consistent with the letter and spirit of the Constitution are constitutional. Here, the court held that Congress' power to create a national bank is valid. Also, in the case of Crugen versus Missouri Department of Health 1990, it was held that while the Constitution protects a person's right to reject life-preserving medical treatment, states can regulate that interest if the regulation is reasonable. Also, in the case of Texas versus Johnson in 1989, it was held that the Constitution protects discretion of the flag as a form of symbolic speech. Here, the court said that government may not prohibit the expression of an idea because society finds the idea itself offensive. In the case of Roe versus Wade in 1973, it was held that the constitutionally implied right to privacy protects a woman's choice in matters of abortion also. In the case of United States versus Nixon in 1974, it was held that neither separation of power nor the need for confidentiality can sustain unqualified presidential immunity from the judicial process. The House began impeachment proceedings shortly thereafter. In the case of Tinker versus Joyce Moynes in 1969, it was held that school dress codes are not in violation of the First Amendment guarantee of the freedom of expression. Also, in the case of San Antonio Independent School District versus Rodriguez in 1973, it was held that the Constitution does not guarantee a fundamental right to education. In the case of Miranda versus Arizona in 1966, the court held that you have the right to remain silent. Also, in the case of New York Times Company versus Sullivan in 1964, it was held that to win a libel case, public figures must prove actual malice on the part of the writer. Also, in the case of Griswold versus Connecticut 1965, it was held that the Constitution implies a right to privacy in matters of contraception between married people. It was held that including the right to privacy in matters of abortion is valid. Also, in the case of Gideon versus Wainwright in 1963, it was held that defendants in criminal cases have an absolute right to counsel. It was later extended to cover any cases where the penalty was of 6 months. In the case of Angel versus Whitale in 1962, it was held that public institution cannot require prayer. It directly approved religion and that was unconstitutional. Also, in the case of Baker versus Carr in 1962, it was held that one person has one vote. It was held that a way that they violate the Equal Protection Clause of the 14th Amendment. In the case of Brown versus Board of Education in 1954, it was held that in the field of public education, the doctrine of separate but equal has no place, as it violates civil rights of 1964. Also, in the case of West Coast Hotel versus Paris in 1937, it was held that a switch in time that saved 9. Here was the statement given by the court. In Mapp versus OU in 1961, it was held that evidence that is illegally obtained by the state may not be used against a defendant in the court, which was given by Justice Potter. Also, in the case of Schenck versus United States in 1919, it was held that speech that presents a clear and present danger to the security of the United States is in the violation of the principle of free speech as protected by the First Amendment of the Constitution. In the case of Neer versus Minnesota in 1931, it was held that the liberty of the press is safeguarded from invasion by the state action. It cannot stop a person from publishing or expressing a thought. In the case of Plessy versus Ferguson in 1896, it was held that Jim Crow laws are constitutional under the doctrine of separate but equal, as the Constitution is color blind. Thank you and have a great day. That's all for the today's presentation. I hope it was knowledgeable.